Today I want to talk about the fact that the EU, Brussels, has gone into regulation-making overdrive. We had the Digital Services Act, the Digital Markets Act, the Data Governance Act, the Data Act, the AI Act, just to name a few of the regulations that are being proposed and created in this town right now. With me to discuss this topic and whether it could point a way forward for perhaps how the GDPR could be enforced and perhaps the centralization of some form of enforcement of the GDPR. I have Pieter van Cleynenbreugel. I hope I didn't mispronounce your name too much. From the University of Liège. I have the MEP Alexandra Geese, who is the Shadow Rapporteur of the Digital Services Act. I have Olivier Micol from the Commission, who is the point man on all things GDPR. And I have former Federal Trade Commissioner turned Microsoft privacy policy linchpin, Julie Brill. To kick us off, I think it would be good to have an overview from Pieter as the academic, who has a much better eye for detail than me as a mere journalist, to talk us through the different proposals and how the enforcement models compare and contrast with that of the GDPR.
Okay, that's quite a challenge to do in 3 minutes, of course, but I'll try. So when you hear about the DSA, the DMA, the Artificial Intelligence Act, and the Data Act Governance and Data Act, the word that comes to mind all the time is centralization of enforcement initiatives. The European Commission taking on a much more direct, much more centralized enforcement attitude. And if one compares this with the system set up by the GDPR, that's indeed a striking finding one immediately comes across. That is that within the framework of the GDPR, there is no such Commission involvement possible. There are national data protection authorities which have to comply with quite a detailed series of requirements in terms of independence, in terms of administrative procedures, in terms of powers they need to have for a start. The GDPR all outlines this in detail, but then those authorities come together, as you all know, within the framework of the European Data Protection Board, which has the power to resolve disputes between supervisors. Now, if you look at the other proposals, you will find some similarities. If you, for instance, take the Digital Services Act, there you also have the obligation for member states to entrust one or more authorities with significant enforcement powers, so-called digital services coordinators, which also have to be independent, have to act in an impartial manner, and have to have a minimum series of powers. Those authorities all come together as well within a European Board of Digital Services Coordinators, or European Board for Digital Services, where indeed some coordination and information exchange can take place, as within the European Data Protection Board. The difference in the DSA would be that in case of conflicts about which type of authority will be competent, that it will be upon the Commission to take on the dispute and to resolve that dispute. Another main difference is, of course, the one-stop shop approach, the OSS approach, which this panel is, of course, about, which has clearly been enshrined in the GDPR, where you have one supervisory authority responsible for a certain kind of data processing activities. Within the DSA, it starts from a one-stop shop approach, but if there's no legal representative of the online digital service providers, if there's no legal representative in one of the member states, then all the member states' authorities may have supervisory powers, enforcement powers. And it will then fall upon the Commission to coordinate much more the whole. The Commission, which can, for very large online platforms, by the way, also take over and even will have exclusive powers to regulate and enforce DSA provisions against those very large online platforms. Moving, because time is ticking, towards the other proposals, Data Governance Artificial Intelligence Act, you will find, again, references to national authorities, competent authorities, which have to be, to a certain extent, independent, which have to respect certain minimum powers, which will come together in an organized network, a European Digital Innovation Board, a European Artificial Intelligence Board, boards which will be chaired by the European Commission, boards which will not necessarily have binding legal enforcement powers. So if you contrast them with the European Data Protection Board, you will see the European Commission plays a more important role, but at the same time, those boards are not necessarily meant to resolve disputes between authorities. To take on another and final example, the Digital Markets Act, I think the Digital Markets Act is very difficult to compare with the system put in place by the GDPR. The Digital Markets Act, even though the European Commission doesn't like to hear that, is in essence competition law. Competition law put in an ex-ante manner, which therefore it makes sense that the European Commission's powers within that framework vis-à-vis digital gatekeepers very much resemble the powers it has vis-à-vis undertakings on the basis of general EU competition law. Given that the focus of the DMA is only on those gatekeepers, basically, if you can compare them, but it's not a fully valid comparison, very large online platforms, then it makes sense that the European Commission will take on their enforcement, big on big, small on small, if you want. By contrast, if you look at the GDPR, and I'll end there, then you'll see that the GDPR is applicable to everyone and everything processing, controlling data within the European Union. The scope of addressees of the GDPR is therefore much larger than of the DMA and, a fortiori, of the DSA as well, which means that a model that is more decentralized could make more sense in the framework of the GDPR than in the other proposals. Having said that, there is a clear tendency in more recent proposals towards more centralized and Commission-centered, European Commission-centered enforcement.
Thank you for that very clear overview of the different proposals and the different enforcement proposals. Alexandra, as someone who's negotiating some of these proposals, what do you think of them and where do you think they need improving in terms of the enforcement models?
Well, I think right now the tendency is sort of a mixed bag, but the complication the European Commission has that it is not only tackling the gatekeepers, and there in the DMA, as was just explained, there was a very clear choice for a central enforcement, but most of these regulations, especially the DSA, which is the one I know best, covers smaller companies as well as large companies, as well as the very large online platforms, and that's very complicated to put together. I'm very happy that in the DSA we managed to have the Commission enforce those provisions that only apply to the very large online platforms. I think that was a major step, and I really have to say this is surprising from the point of view of the member of European Parliament. This was not requested by the European Parliament, but it was requested by Council, because the member states themselves recognized that a common and centralized enforcement really safeguards the member states' interest. Because I think the problem we have with GDPR right now that there is a competitive advantage for those very large companies, and I don't need to name them, that are headquartered in a country where, let's say, enforcement standards might not be as high as in other ones. That's a problem for the internal market because it punishes basically smaller, medium-sized, and even large, but not that large companies that really have to comply with GDPR and which are held to high standards in their own member states. And I come from a member state, Germany, where we have 16 different applications, so we don't only have the problem of different enforcement between the national level and the European level, but even within the country, we have different kinds of standards according to the state data protection authority. And there it's really the private sector that is saying we need to have common enforcement, and I think we do need that on a European level as well, and there's a growing awareness we do need that, because otherwise what we are going to have and what we're already seeing is not only what we used to have and criticize in the past, forum shopping, we're going to have enforcement shopping, that especially large companies choose the country of establishment according to low enforcement standards. And this is going really to hamper the internal market and also to harm our democracies, because people, we lose credibility because citizens see they have to fill in 10 forms in order to sign up their kid for the local soccer club. But their data is being used by a couple, I mean, just to say Meta or Google, who are not held up to the same high standards. And this is really a problem for the credibility of GDPR in the first place. And if the same thing happens to us with the DSA, it will really undermine the credibility into regulation at large.
Thanks very much, Alexandra. Olivier, what we're seeing with these proposals is, I think, a shift in seeing the Commission take on an increasing role in enforcement. Is that how it's seen inside the Commission?
Well, I mean, I will, of course, first of all, hello to everybody. I'm very honored to be on this panel with these other speakers. But I will not start by saying that the Commission does not want more power. I will not argue against that. But we have to see, and this was very also clearly explained by Pieter in the introductory remark, we are looking at different objectives. We are looking at enforcement under different conditions. So, and I would not agree with the, I mean, some narratives that we hear that, this so-called centralization would be a reaction to a problem of enforcement of GDPR. This I would absolutely not subscribe to. We are aware that there are problems, that things can be improved. This is perfectly fine. But this, and I will come back to that maybe later in the discussion. But when we look at the DSA, the DMA,